The European Union has just finalized the AI Act. It is a landmark piece of legislation, one that is very likely to set a global standard for governing this technology. It has been meticulously designed to manage the risks of the AI we have today. But this raises a profound question. Is this intricate framework prepared not just for current systems, but for the far more powerful, general-purpose AI of tomorrow? Perhaps even what we might call AGI? To understand how the Act confronts this challenge, we will proceed through 6 key areas. We will examine its fundamental structure, see how its definitions assign responsibility, understand how it categorizes AI by its power, review the different duties that apply, trace the chain of liability, and finally, consider whether it can truly keep pace with innovation. Let's begin with the Act's core design. Its most innovative feature is a 2-layered structure, which was specifically created to manage AI risks at 2 different levels, at the point of application and at the model's very foundation. This comparison reveals the evolution in the legislator's thinking. The Act was initially designed with a traditional product safety logic. It focused on specific high-risk applications, for instance, an AI tool used in medical diagnostics. But with the rapid emergence of powerful models like GPT-4, it became clear that this was not enough. So a second horizontal layer was added to regulate the foundational models themselves, the very engines that power countless applications. This allows the law to address risk directly at its source. For this new layer to function over time, the law required a definition that could endure. Instead of using a term like foundation model, which could easily become dated, it introduces the concept of a general-purpose AI model, or GPAI. The key phrase here is significant generality. This breadth is intentional. It's a strategy to give regulators the flexibility to apply the law to new forms of AI as they are developed, ensuring the Act remains relevant. This careful attention to definitions is absolutely critical, because within the AI Act, these terms are not merely academic. They are, in fact, powerful legal instruments that draw the lines of responsibility and determine who is ultimately held accountable. For instance, the Act makes a crucial distinction between a GPAI model, the underlying engine, and a GPI system. The system is the interface that a person actually interacts with, such as a chatbot or an API. Legally separating the engine from the vehicle, so to speak, is fundamental to determining who is liable, the creator of the model or the developer of the application. And then we have this vital concept, systemic risk. You can think of this as a special legal designation for the most powerful AI models, those whose capabilities are so significant that they could have wide-ranging effects on society. When a model is placed into this category, it triggers the most stringent level of scrutiny and obligation under the law. So how does the Act determine which models are powerful enough to warrant this systemic risk designation? It employs a methodical sorting mechanism, which we can call the systemic risk gateway. The essential regulatory question is this: how do you objectively distinguish a standard general-purpose AI from one that poses a potential systemic risk? The Act provides a 2-part test to answer this. First, there is an objective quantitative check. It is based on the cumulative computing power used to train the model, measured in floating point operations per second, or flops. However, the lawmakers recognized that this metric was brittle and could quickly become obsolete. Therefore, they built in a crucial qualitative safety net. Even if a model falls below the computing threshold, the European Commission retains the power to designate it as systemic if it has a very large number of users or demonstrates other high-impact capabilities. We already have a real-world example that illustrates why this safety net is so vital. We're seeing what some call the DeepSeek problem, where new models are achieving frontier-level performance while using significantly less computing power. These efficient models could easily fall below the flops threshold, which makes the Commission's power to qualitatively designate them as systemic an absolutely essential tool for future-proofing the law. Once a model has been classified, it becomes subject to one of 2 distinct tiers of legal obligations. The principle is simple: the more powerful the AI, the more demanding the duties. This table presents the distinction quite clearly. All GPI models must adhere to baseline transparency duties. They have to provide technical documentation, supply information to developers who use their model, and maintain a clear policy on copyrighted training data. But for models designated with systemic risk, the obligations escalate dramatically. They must conduct intensive model evaluations, including adversarial testing or red teaming, actively work to mitigate systemic risks, and report any serious incidents to the regulators. These are substantial and costly requirements. Now, the Act does attempt to foster innovation by creating a partial exemption for open source models. However, this exemption is fragile. If an open source model becomes exceptionally successful and widely adopted, its very popularity and market reach can trigger a systemic risk designation. At that point, it loses its exemptions and must face the full compliance burden, a dynamic some critics have termed a popularity penalty. This brings us to one of the most consequential aspects of the Act, the allocation of liability. It establishes a clear chain of responsibility designed to trace accountability from the creator of the core AI model all the way to the entity deploying the final application. The central principle here is what is called the duty to enable. The provider of a foundational GPAI model is not automatically liable for a high-risk system that someone else builds using that model. Instead, their legal obligation is to enable compliance. They must provide the downstream developer with all the necessary technical information and documentation that developer needs to ensure their own product can meet the high-risk requirements. Liability flows downstream, but only because information is legally required to flow downstream first. This flow of liability, however, creates a significant risk for businesses and other organizations that use AI. It is a risk we can refer to as the repurposing trap. Let's trace this process, as it is of critical importance. Imagine a company uses a standard AI chatbot for customer service inquiries, a low-risk task. In this case, the legal liability remains with the original developer. But then that same company decides to modify the chatbot to screen job applications, which the Act defines as a high-risk activity. By making that substantial modification for a high-risk purpose, the company fundamentally alters its legal status. It is no longer just a user or deployer. It is now legally considered a provider and inherits the full and considerable legal responsibilities that come with that role. All of these rules, definitions, and liabilities bring us to the final and most critical question. Can this complex legal framework adapt more quickly than the technology it seeks to govern? This is, in effect, a race against the future. The architects of the Act anticipated this very challenge and built in several mechanisms for adaptation. A central AI office will monitor the entire ecosystem, a scientific panel of independent experts will issue alerts on emerging risks, and the lists of high-risk and prohibited practices will be regularly reviewed. Crucially, the Commission is granted the power to quickly update technical criteria, like the FLOPS threshold, through a fast-track legal process known as delegated acts. This allows the rules to be modified without rewriting the entire law. In the end, the long-term viability of the AI Act does not depend solely on the rules as they are written today. Its resilience hinges on the ability of regulators to skillfully use these more flexible, soft mechanisms, like the power to designate new systemic risks and the power to issue delegated acts, to stay ahead of technological change. And this leaves us with a final, profound question. The European Union has meticulously constructed its regulatory engine, designed to guide artificial intelligence toward a safe and beneficial future. But the ultimate test is whether that engine can keep pace in a race against a technology that is not only accelerating exponentially, but is, in fact, learning to rebuild and reinvent itself as the race unfolds.